to this point has been good, and we'll do our best not to change that if that's the case. Who will begin?
Mr. President, the parties have agreed that the respondent will proceed first with the issue of jurisdiction, followed by the claimant with jurisdiction.
You were respondents?
Yes, Mr. President. Followed by the claimant.
I don't think there are any objections to that.
Okay. So it will be followed by the claimant with jurisdiction and the merits, and then followed again by the respondent with the merits.
Any objections?
No, it was agreeable to the parties.
That's fine. And do we have a timekeeper?
Yes.
And your time, how much time do you want for the
Respondent jurisdiction. I will be speaking for 18 minutes with a 2-minute reply.
how many minutes?
18.
18. Okay, and the reply?
I will be speaking for 17 minutes on the jurisdiction of the claimant with 1 minute for rebuttal if necessary.
Okay. We'll begin.
Yes, thank you, Mr. President. Thank you, Mr. President, members of the Tribunal. What we have here today is a bilateral investment treaty which contains an exit arbitration clause and a joint venture agreement containing a commercial arbitration clause. This is an ordinary commercial dispute like any other. The parties' contractual bargain to resolve this dispute by way of commercial arbitration must be honoured. This tribunal should therefore not proceed to the substantive dispute for 3 reasons. Firstly, the commercial arbitration agreement is a withdrawal of the respondent's standing offer to exit arbitration. Secondly, and alternatively, all disputes should be heard together by the commercial tribunal in order to avoid 2 separate sets of proceedings. And thirdly, Veritech's conduct is not attributable to the respondent. Turning now to my first argument, that the commercial arbitration agreement is a withdrawal of the respondent's standing offer to exit arbitration. Members of the Tribunal, by Article 25, subsection 1 of the Exit Convention, party consent is a precondition to this tribunal's jurisdiction. By Article 11 of the Berestan Opulentia Bit, the respondent extended an offer to the claimant to resolve disputes with respect to investments by way of exit arbitration. Article 11 represents a mere standing offer to arbitrate and does not by itself constitute consent for the purposes of the Convention. It is only once this standing offer is accepted by the claimant investor that consent is perfected. Therefore, prior to being accepted, the mere unilateral standing offer may be withdrawn by the respondent host state, and that is exactly what has occurred today. Before the respondent's standing offer was ever accepted by the claimant, the parties instead agreed to resolve their disputes by way of commercial arbitration agreement. Could the members of the Tribunal please direct their attention to page 19 of the facts, where you'll find this commercial arbitration clause at clause 17. As you can see, members of the Tribunal, at clause 17, the parties instead agreed to resolve any dispute arising out of or relating to the joint venture agreement only by way of commercial arbitration under the 1959 Arbitration Act of Berestan. The words arising out of or relating to are very wide words indeed, giving the commercial tribunal jurisdiction in about as wide terms as can be drafted. Furthermore, as you can see in the final sentence of the clause, the parties waive any objections which they have to the commercial proceedings and irrevocably submit to the jurisdiction of the commercial tribunal. In the recent 2008 exit case of Occidental Petroleum and the Republic of Ecuador, the tribunal held that a waiver clause, very similar to that in the present commercial arbitration clause, revealed the parties' true intentions to exclude disputes from the scope of exit arbitration in favour of the exclusive jurisdiction of the Ecuadorian administrative courts.
Counsel, what sort of weight should we give that case?
Well, Mr. Arbitrator, it is an exit case, and this is an exit proceeding. Due consideration should be paid to earlier decisions of the exit tribunal in order to advance the body of law and provide consistency and predictability for both investors and host states. So therefore it should be given great weight, Mr. Arbitrator. Members of the tribunal, by implementing this commercial arbitration agreement, the parties consciously chose to depart from the original standing offer. At that point, it became impossible for the claimant to accept the respondent's previous offer, and party consent was never perfected. Accordingly, the parties have not satisfied the requirement of consent embodied in Article 25, subsection 1 of the Exit Convention, and this tribunal has no jurisdiction. Turning now to my second argument, that the Commercial Arbitration Tribunal is the only forum competent to decide both the claimant's bit and contract-based claims together. Members of the tribunal, it is neither good business nor good commercial sense to encourage two separate sets of proceedings, where one forum can conveniently and promptly deal with the entire controversy. Competing and potentially conflicting litigation must not be encouraged. In the 2002 House of Lords case Donahue and Armco, the court held that the ends of justice are best served by the submission of the whole dispute to a single composite trial in the only forum in which one can be procured. Members of the tribunal, unlike this tribunal, the Commercial Tribunal is the only forum competent to decide both the claimant's bit and contract-based claims. The present exit arbitration clause is very narrow and restricts exit's jurisdiction to treaty-based claims. The exit tribunal in SGS in Pakistan held that an exit arbitration clause, very similar to that in the present case, did not encompass claims of an essentially contractual nature, stating that such narrow words cannot be read as vesting the tribunal with jurisdiction over claims resting on contract. Furthermore, members of the tribunal, the parties cannot have intended the far-reaching and burdensome consequences of treating a breach of contract as a violation of international law under the umbrella clause of Article 10 of the BIT. The exit tribunal in SGS in Pakistan refused to support a broad interpretation of an umbrella clause because it would become impossible for investors to validly agree to an exclusive jurisdiction clause in a contract. They will always have the hidden capacity to bring contractual claims to BIT arbitration. Mr. President, members of the tribunal, to divide up this dispute between commercial arbitration in Beristan and exit arbitration here today would be unjust, time-consuming, expensive, and a waste of both the parties and the tribunal's resources, and thus cannot be supported. Accordingly, all of the present disputes should be heard together by the Commercial Tribunal in order to avoid the uncommercial result of fragmented litigation.
Just a quick question. If we find that we do have jurisdiction, will you, as respondents, move the commercial arbitration panel to stay proceedings?
Mr. Arbitrator, the commercial proceedings at this point are between Veritech and the claimant. The respondent has not instituted any commercial proceedings at this point. Turning now to my third argument, members of the tribunal, that the acts of Veritech are not attributable to the respondent. Members of the tribunal, if the acts of Veritech cannot be attributed to the respondent, this exit tribunal does not have jurisdiction under Article 25, subsection 1 of the Exit Convention. Members of the tribunal, the mere fact that the respondent has a majority shareholding in Veritech is not in itself sufficient to establish attribution. As stated by the Exit Tribunal in Mathesini in Spain, for attribution to be satisfied, the specific activities of Veritech must essentially be governmental rather than commercial in nature. Members of the tribunal, Veritech was formed within a privatised telecommunications market. Further, Veritech's principal activity was to participate in the development of satellite network telecommunications services worldwide, while the provisions of while the provision of telecommunication services within its own territory may be deemed a governmental function, providing services to other countries is certainly not. These facts point to the conclusion that Veritech's purpose was to generate profits in a competitive local and global market, rather than to operate as a government instrumentality.
Isn't one of your arguments that there's been national security breaches here? So there is a governmental connection, is there not?
Yes, Mr. Arbitrator, we argue in the alternative that we relied on national security. However, not to invoke the buyout, and that's what this tribunal needs to consider today. The tribunal must consider whether Veritech's invocation of the buyout was governmental or commercial. The respondent sent its civil works force to remove claimant personnel from the SatConnect site.
So you're willing to take issue by issue and ascertain whether or not it's a government fulfilling a governmental function?
Yes, Mr. Arbitrator, that's what we must look at. We must look at
And the entity itself has no relationship then to the government in one situation and another situation? It does?
Well, Mr. Arbitrator, Veritech obviously has a relationship with the government because it is the government 75% owns Veritech. However, that's not sufficient enough to establish attribution as held by
What is the law of attribution then? What are you relying on to determine whether or not certain acts are attributable to the government?
Well, the Exit Tribunal in Mazzini, Spain is the leading authority on this, Mr. Arbitrator, and that has been supported by numerous other exit tribunals, including Czechoslovakia and the Slovak Republic, Salini and Morocco, to name a few. But, Mr.
What do
Arbitrator,
those cases involve?
in those cases, Mr. Arbitrator, the tribunals looked at the specific conduct of the entity to determine whether or not it was governmental or commercial in nature. Mr. Arbitrator,
And what makes it governmental in nature?
Mr. Arbitrator, it is not, nothing is governmental here today in relation to the invocation of the buyout clause. It was purely commercial. Veritech's invocation of the buyout clause, under the buyout clause, a breach of confidentiality grants Veritech the option to purchase all of the claimant's interest in the project. Now, this option is very valuable to Veritech because it essentially gives Veritech the contractual right to acquire all of the claimant's stock at cost price. In light of these facts, it would be extremely uncommercial for Veritech to waive its rights under the buyout clause. In fact, had Veritech failed to exercise the buyout clause, it could potentially suffer serious commercial implications as a result. Mr. Arbitrator, the acts of the Civil Works Force had absolutely nothing to do with the invocation of the buyout clause. That occurred at a later date and did not have anything to do with the buyout clause.
But if the buyout clause were to be activated against Tel Aviv on the rumor that there had been a leak and not on actual proof that there had been a leak, it would be confiscatory in nature because of the 2 years of work that has gone into this contract and no reward for that.
Mr. President, this is irrelevant in establishing attribution. In order to establish attribution, this tribunal must determine whether Veritech's invocation of the buyout clause was governmental in nature, irrespective of whether or not it was justified or was fair or was on just grounds. Members of the tribunal.
And what is the basis of that claim? That's the determination. In other words, what decides whether or not it's governmental or not? The action is governmental or not.
Mr. Arbitrator, the tribunal, exit tribunals did not go any further as to say whether or not it was governmental or commercial. I think we should just take a logical approach to that.
There's no law here.
Yes, the exit tribunals in Mazzini in Spain, just to name a few. But I cannot assist you any further on that matter, Mr. Arbitrator. Members of the tribunal, the exercise of the buyout clause was dictated by commercial common sense and was in no way governmental in nature. Veritech was quite simply acting like any other rational commercial entity by protecting its commercial interests and taking advantage of its commercial right. Accordingly, Veritech's conduct is not attributable to the respondent, and this tribunal has no jurisdiction. In conclusion, members of the tribunal, this is a normal commercial dispute like any other. the parties have agreed that claims arising out of or relating to the joint venture are to be governed by the commercial arbitration agreement at the exclusion of any other forum. To ignore this express bargain would be to render any freely negotiated dispute settlement mechanism in a contract a dead letter. Such a result is wholly uncommercial and cannot be supported. Thank you, members of the Tribunal.
Members of the Tribunal, my name again is Christine Van Geyn, and I'll be addressing the jurisdictional claims on behalf of Televative Incorporated Claimant. The Respondent has just attempted to evade this tribunal's jurisdiction by suggesting that the claims should be sent to commercial arbitration in Barristan. The Respondent doesn't want there to be two simultaneous arbitrations, both here and in Barristan, and we agree. However, because the Respondent is bringing treaty-based claims, those claims can't be resolved by a contractual arbitration, a contractual commercial arbitration, which doesn't have the capacity to address commercial treaty claims, and in any event, doesn't apply international law. Claimant will be bringing up three issues. First, that on a prima facie basis, which is all that's required, these claims are based in treaty, not in contract. Second, to the extent that there are elements of contract in claimant's claims, these elements are brought within this tribunal's jurisdiction through the umbrella clause in Article 10 of the BIT, which is found on page 13 of the record for your reference. While I address the umbrella clause, I'll also address the question of attribution. The third issue claimant will be addressing is that the forum selection clause in the joint venture agreement has no effect on this tribunal's jurisdiction. I'll begin with the first issue, the prima facie analysis. Because these claims are based in treaty, Article 25, Sub 1 of the ICSID Convention gives this tribunal jurisdiction. There's a difference in the legal basis when a claim is based in treaty or whether it's based in contract. This is established by, for example, the SGS Pakistan decision, to name just one. For the purposes of characterization as a claim as either contract or treaty, claimant just needs to show that on a prima facie basis, the claims, if proved true, would fall under the provisions of the BIT. All claimant needs to show is that there's prima facie state interference with claimant's investment. In this case, just a cursory consideration of the facts reveals the prima facie test is satisfied. So in this case, we have Respondent has perpetuated misinformation about claimant by using a high-ranked government official to leak information, to spread information in the media, unsubstantiated information. We have Respondent using its state entity of Veritech to trigger a buyout and an unlawful and an incorrect buyout, not in conformity with the corporate regulations. And conveniently, this buyout was done when the value of SatConnect, the joint venture, had crystallized. So after years of effort, hard work, investment by claimant, right when the fruit of the effort was ripe for the picking, Respondent came in and picked that fruit and seized it using military force. So we had the military troops of Barristan come in, seize claimant's property, seize claimant's assets, and evict claimant's personnel from the property. None. Yes, Mr. Archer.
Just a quick question, because it seems like you're glossing over the effect of the Respondent's argument that consent has been revoked by in other words, the consent that is laid down, or the invitation, the standing offer has been revoked, I should say, of Article 11 of the BIT, and by entering into the joint venture agreement and having an exclusive dispute resolution clause included in here.
Yes,
Are
Mr.
you addressing that, or am I jumping the gun, or are you...
I'll be addressing that in my third submission, but I'm happy to tell you right now that
We can wait.
I'd just like to say that if there is a waiver, that waiver would only be for the settlement of contract claims, purely contract claims, but here we have a respondent acting wholly outside of the scope of the contract. Respondent can't now rely on that contractual dispute settlement mechanism to resolve a dispute that arose when it acted outside of its contract.
So your essential argument is that the acts were governmental, to respond to the respondent's argument.
Yes, Mr. Arbitrator, these are sovereign acts. The act of sending in a military is undeniably a sovereign act. I'll be addressing attribution with the umbrella clause, which I can get to right now. But before I address that, I'd just like to make one point on the prima facie test, and that's to analogize this case to one case, Bandir in Pakistan, where on a prima facie basis, that tribunal held that the use of the civil engineering force of the military, just like in this case, was enough on a prima facie basis to hold jurisdiction. I'll now address...
That was an ICSID.
That was an ICSID decision. That's correct, Mr. Arbitrator. I'll now address the issue of the umbrella clause, which is located on page 13 of the record. And before I address that, there's the threshold issue that you raised, Mr. Arbitrator, of attribution. To find that the act of an entity is attributable to a state, that the act of Veritech is attributable to the state of Beristan, we apply a structural and functional analysis. As my opposing counsel mentioned, this was established in the Mafasini decision. Unfortunately, my opposing counsel hasn't applied the test correctly. We look at first at structure, which creates a rebuttable presumption that attribution exists. So from the structure of this organization, Veritech, we see that there's a 75% ownership by the state. There's a 25% ownership by government-connected elites, and the Minister of Telecommunications sits on the board. Although it's not quite clear what kind of influence the minister has on that board, it would be strange to assume that the minister regulating the industry, sitting on a corporate board, would not be a significant figure on that corporate board. The structural analysis on its own is enough to satisfy the attribution, but we can also look at function. So in this case, we have Veritech, a telecommunications company, but it's not only telecommunications, it's telecommunications infrastructure. This is a company involved in the building of satellite infrastructure networks. So to analogize to a case, we had the Salini and Morocco decision, an ICSID decision, which held that the construction and maintenance of highways is a government function. The construction and maintenance of satellite telecommunications networks, and in this case, which can be used for military purposes and will be used for military purposes, as we see in paragraph 6 of the facts, is undoubtedly a government function. We have more evidence of the government function of Veritech. For example, Beristan was a guarantor of Veritech's loans. We have coordinated action between Veritech and Beristan. So when the buyout required Claimant to leave within 14 days, right at that timeline, right as that time expired, we had Respondent's military coming in and coordinating with the corporate entity Veritech to remove Claimant's personnel. And finally, we have Respondent themselves bringing the claim, the defense of essential security. If Respondent's bringing the claim of essential security, surely they believe that this entity has a public purpose. So, attribution being satisfied, we should consider the effect that the umbrella clause has on the contractual element of Claimant's claims. The contractual element being whether or not the buyout was correct, whether or not there's a material breach of the contract, which my co-counsel will be addressing. So, for umbrella clauses, which is in Article 10, we have a range of different decisions. And we have on one end, we have this big spectrum. On one end we have SGS Pakistan, on the other one we have Euriko and Poland, which is we have a restrictive interpretation and a broad interpretation. And the restrictive interpretation has been harshly criticized in academic literature and in decisions. So for example, SGS Philippines said the reasoning in SGS Pakistan, these had similar umbrella clauses, said that the reasoning was unconvincing and that it gave no clear meaning to the umbrella clause. The literature has said that the restrictive interpretation unjustifiably, this is citing Dolter and Schur, unjustifiably departs from the requirements of the Vienna Convention on the Law of Treaties. So which requires us to give the words of the treaty the ordinary meaning. And in this case, we have this umbrella clause which states, I'll read it for the tribunal if you're not familiar. Each contracting party shall constantly guarantee the observance of any obligation it has assumed with regard to investments in its territory by investors of the other contracting party. So the plain meaning would be any obligation means any obligation. And that was the conclusion reached in Euriko and Poland, which found that any obligation, contractual or not, comes within the jurisdiction of a treaty. But Claimant doesn't need to push this tribunal quite so far. We'd be satisfied with the reading followed by Noble Ventures and SGS Philippines, which found any contractual obligation with regards to an investment brings the claim within this tribunal's jurisdiction. This reading is consistent with the history of umbrella clauses. We consider the work of Anthony Sinclair, who discussed the birthplace of the umbrella clause was the oil platforms case. And in that case, it was unquestionable that the intention of those parties was to bring contractual disputes between the UK and Iran within treaty jurisdiction. We should also consider...
Why should we give that way? Mr. Sinclair. Why should we give his commentary?
Because that's a contextual factor that the tribunal can consider. It by no means
contextual in what sense?
In the sense that ICSID tribunals commonly refer to scholarly works in rendering decisions, and that this practice is justified for the reasons that it's justified because these are leading thinkers in international arbitration, and it's customary practice by ICSID tribunals.
Well, granted, it is a long-standing European tradition to give weight to the writings of prominent jury counsels.
Why is Mr. Sinclair a prominent jurist or arbitrator?
Well, Mr. Sinclair is well known in investment arbitration. I don't have his biography handy, but I'd be happy to discuss this in a post-hearing memorandum if it would please this tribunal. So, based on the history and the jurisprudence of ICSID tribunals, Claimant's position is that the umbrella clause has the effect of bringing contractual elements of the treaty claims within this tribunal's jurisdiction. I'll now move to my third and final submission, which is that the forum selected in a contract by private parties can't trump the forum selected by sovereign states in a treaty. Clause 17 of the joint venture agreement, located on page 19 of your record, has no effect on this tribunal's jurisdiction because Claimant's conduct, as I mentioned, is wholly outside of the scope of the contract. None of those acts that Respondent engaged in were contemplated by the parties when they signed the joint venture agreement. Respondent can't act outside of the contract and then rely on the contract to resolve its disputes. Even if the forum selection in the joint venture is an exclusive choice, and even if there was waiver, it wasn't a waiver of bit claims. Moreover, for policy reasons, this tribunal should hear all the treaty claims in one place. In this tribunal, we're here in a non-bifurcated hearing, which is unusual. And we can hear all of the claims here today all at once and resolve the dispute in a speedy and efficient way, which are two of the goals of international investment arbitration. And accordingly, this tribunal should find that it has jurisdiction to hear all of claimant's claims.
What law will apply then, should we decide to decide all claims?
We would apply the Bearstan law, but under Article 42 of the ICSID Convention, we also apply international law. If there are any further questions, those are my submissions.
I just want to hear you connect the arguments that respondents have advanced that I previously mentioned, where they say that under Article 11 of the bid, we extended an offer for exit arbitration, but that offer was revoked by Article 19 of the joint venture agreement. I mean, you kind of obliquely referred to it, but I would like to hear a more direct response to it.
Article 11 is what gives parties, Bearstan and Opulentia, Claimant is a national of Opulentia, the ability to bring treaty claims to this tribunal. The waiver...
But you are aware that it is an offer and consent procedure under the exit convention.
Yes, Mr. Arbitrator, the language of Clause 17, the joint venture agreement, also uses offer and acceptance language. It says that the parties may submit to arbitration. It can be no more exclusive than this choice of form. Thank you.
Thank you, Mr. President, members of the Tribunal. The claimant has raised several issues, but I will restrict myself to two. Firstly, a breach of contract is not by itself a breach of international law. In the words of the ICSID Tribunal and SGS in Pakistan, the parties cannot have intended the far-reaching, unqualified, sweeping and burdensome consequences of treating a breach of contract as a breach of a bid. This tribunal should refuse to accord the umbrella clause a broad interpretation, because otherwise an investor could always defeat the state's invocation of a contractually specified forum and render any mutually agreed dispute settlement mechanism in a contract a dead letter at the investor's choice. Such a result is so contrary to the basic rules of fairness and pactus sunt servanda, it cannot be supported. And secondly, members of the tribunal, unlike this tribunal, all of the present claims fall within the scope of the commercial tribunal. It is a fundamental principle of law that the scope of an arbitrator's powers in a given case depend fundamentally upon the words of the arbitration clause. The words arising out of or relating to in the present commercial arbitration clause is very broad and gives the commercial tribunal jurisdiction in about as wide terms as can be drafted. In J.J. Ryan and Son and Phone Blank Textile essay, the United States Second Circuit Court of Appeal held that such wide-reaching words encompass every dispute between the parties having a significant relationship to the contract, regardless of the legal label attached to the dispute, and therefore all of the present claims fall within the scope of the commercial tribunal's jurisdiction, regardless of whether they sound in contract, tort, statute, or treaty. Members of the tribunal, this is an ordinary commercial dispute like any other. The parties' contractual bargain to resolve this dispute by way of commercial arbitration must be honoured. Thank you.
As no new issues have been raised in rebuttal, I waive my rebuttal.
You sure?
Yeah.
We're going to take the issue of jurisdiction under submission, and as long as we have you all here at this time, we wish that you proceed on the merits of the case we do determine to accept jurisdiction, so that we can rule on all issues at once. Not so different from arsenal retraction.
Mr. President, members of the Tribunal, my name is Sven Volker, and I will be addressing the merits of this case on behalf of the claimant. The essence of this case is that the respondent wrongfully excluded claimant from from a joint venture enterprise, SatConnect, the purpose of which is the development and implementation of satellite technology. Conveniently, this wrongful exclusion occurred at a point in time when the satellite technology was about to become operational and generate profits. This raises not only issues of contract, but also various breaches of treaty. In the interest of time, I propose to highlight two of these treaty breaches, expropriation and FET, while respectfully referring the Tribunal to our written submissions for the remaining breaches of treaty. And if it is agreeable with the Tribunal, I will address the treaty breaches first, for then advancing to the material breaches of contract committed by Respondent. On the issue of expropriation, in ICSID cases such as Metalflab, expropriation is defined objectively as the taking of property by a state. This is what occurred in the present case on September 11, 2009, when the Boristian military invaded SatConnect's premises, expelled all Claimant associated personnel, and thus gave effect to the Respondent's claim of sole legal ownership over SatConnect. Article 4...
You're not saying that they didn't have the power to do it. We're not talking about the right, but the power to do it. They had that. You accept that.
I'm not sure I
The
understand.
Barrister had the right to do what they did. Rather, the power to do what they did, whether or not they had the right.
They certainly had the power to send the military, but did not do so rightly, yes.
Okay. The only question for us then is the rightness of what they're doing.
Absolutely. For this purpose, I would like to refer the Tribunal to Article 4, Section 1, Paragraph 2 of the Barrister and Valencia bit, which can be found on Article 11, page 11 of the record. In this article, 4 conditions are imposed on a lawful expropriation. Namely, that the expropriation must be executed for a public purpose, against immediate, full, and effective compensation, on a non-discriminatory basis, and in conformity with all legal provisions and procedures. Claimant will seek to show that Respondent violated at least 3 of these 4 cumulative conditions. Cumulative means that if Respondent violates any of these, the expropriation must be considered illegal. It is Claimant's position that Respondent did not act for a public purpose, Respondent did not pay full and effective compensation, and Respondent denied Claimant due process of law. I propose to deal with these points in turn. On the point of a public purpose, Respondent alleges that his actions were justified on national security grounds. While the maintenance of national security is certainly a public purpose, Respondent cannot simply make an allegation of a threat to national security without providing any evidence to support it. This point was made by the Tribunal in ADC in Hungary, where it was said, quote, "A treaty requirement for public interest requires some genuine interest of the public. If mere reference to public interest can magically put such interest into existence and therefore satisfy this requirement, then this requirement would be rendered meaningless."
Isn't national security a public purpose?
Yes, Mr. Arbitrator, we agree. However, it is our position that this national security or threat thereto should be proved on some basis. In this particular case, Respondent's entire case is built on a leak, of a presumed leak of information, confidential information, by Claimant to the government of Valencia. However, the record makes clear on 4 occasions that Respondent cannot prove that such a leak ever occurred. The only piece of evidence offered by Respondent, is an anonymous tip-off given by a Boristian government official to a journalist of the Berestan Times. Not only is this a rumor, but it is a rumor spread by Respondent itself. Nothing demonstrates the groundlessness of Respondent's claims better than such frivolous use of self-fabricated evidence. The burden of proof therefore remains on Respondent to provide at least some evidence that there was a threat to national security, failing which public purpose has not been established. This is therefore the first instance in which Article 4 of the bid was breached. Unless there are any further questions on this point, I will proceed with full and effective compensation. Article
Please
4.
continue, we're not bashful if you want to.
Thank you. Article 4, Section 1, Paragraph 2 of the bid, again on page 11 of the record, defines full and effective compensation, which is owed to Claimant, as a sum equivalent to the real market value of the investment. Tribunals such as Starrett Housing and Iran, a decision widely cited, defines real market value as, quote, the price that a willing buyer would pay to a willing seller in circumstances in which each had good information, each desired to maximize his financial gain, and neither was under duress or threat. Now clearly such a definition of real market value encompasses more than just sunk investment costs, than just the money paid into the investment prior to the expropriation. Article 4, Section 1, Paragraph 3 of the BIT makes this point by holding that, quote, market value shall be calculated on the basis of a fair appraisal of the establishment's constitutive and distinctive elements, as well as of the firm's activities, components, and results. It is our position that a distinctive element, an important component of a project for the development of satellite technology is intellectual property. In fact, arguably, prior to the technology becoming marketable, intellectual property is the most valuable asset of the project. Claimant has not been compensated for this loss of valuable intellectual property. Article 1D of the BIT specifies that intellectual property, commercial trademarks, patents, are in fact part of an investment. The loss of this investment has to be compensated, which has not happened in this case.
I'm not clear how this was lost, because the CWF simply occupied certain premises of the satellite company, and how does that affect the intellectual property rights that your client still possesses?
Mr. Arbitrator, what has happened is that in fact claimant's rights over the property through the shares in Satconnect have been effectively lost. There's no more ability to exercise the control that comes with the ownership of shares or benefit from the value of the shares in the company. It is our contention that the value that has been paid or that has not been paid, that claimant has put into respondent has put into an escrow account, does not reflect the true value of the company because it does not reflect the property value held by that company. Now, the third instance in which Article 4 of the BIT was violated is that claimant was denied due process of law. In the words of Article 4, Section 1-2 of the BIT, an expropriation must be conducted in conformity with all legal provisions and procedures. This broad wording does not exclusively refer to domestic law, meaning that this tribunal should interpret it as also referring to international minimum standards of procedure. In addition, clarification 120 of the record makes clear that due process is also a domestic Buristian constitutional requirement. Therefore, under any standard, claimant should have been awarded an opportunity to be heard. There should have been some reasonable advance notice, a fair hearing, or an unbiased adjudicator. This point was made, for example, by the Tribunal ADC in Hungary. On the facts, respondent's conduct constitutes a mockery of procedural justice. Instead of seeking the decision of a neutral fact finder to proceed to the conduct that it did, it simply took the law into its own hands, exercised judicial and police powers in one sweep, and took property, took value away from our client. The importance of a fair hearing and of a neutral fact finder was emphasized in numerous exit decisions, such as Metalclad or ABC. The point is that because of respondent's conduct, irreparable damage has been caused. Had this dispute been decided prior to the expropriation, had this dispute been heard prior to the expropriation, the business relationship might have been salvaged. This might have been settled in a civilized manner, not destroying all trust between the parties. As the matter stands right now, future cooperation is rendered impossible. This is for the third instance in which respondent breached Article 4. Unless there are any further questions on expropriation, I propose to proceed to fair and equitable treatment.
I was just a little confused about the internal procedures. Didn't the board vote to buy out, and therefore they complied with the agreed to internal procedures?
Mr. Arbitrator, if you would like, maybe I should for now skip the issue of FET and go to the contractual claims, which are related to exactly what you're referring to.
Okay, I'm not trying to jump ahead. I was just trying to say that if you're alleging a due process argument, doesn't that go to that?
On the facts, what has happened is that the decision to invoke the buyout clause was first taken by Veritech, who, it is our argument, whose conduct can be attributed to the state. And then SatConnect, and the issue of the board of directors, which you're referring to, is only a consent to the buyout. This distinction is important. The buyout was invoked by Veritech, by the respondent, and then only consented to. Now, as regards the consent, it is our submission that the consent was invalidly given, and therefore can have no effect. This also goes to the breach of contract. In fact, this is an important matter where the facts of the case come into play. The consent that Mr. Arbitrator is referring to, the board procedure, is a board meeting that happened on August 27th, 2009. In that board meeting, 5 directors out of 9, all respondent appointed, were present at the beginning of the meeting, in addition to 1 claimant appointed director, and this claimant, therefore 6 directors were present. However, the claimant appointed director left before the end of the meeting when she found out that the board was going to proceed on a vote on the buyout. When she knew, because before there was no agenda distributed, she could have no idea what was going on. All of a sudden she's presented with this fact. We're going to vote on the buyout. She realized what was going on and left. This is in the facts. This is in the clarifications. The clarifications also make clear that she did not take part in the voting.
Does that invalidate the buyout?
What invalidates the buyout, Mr. Arbitrator, is the information is given in clarification 200. A quorum of 6 directors, 5 directors by respondent appointed, 1 claimant appointed, is needed, quorum of 6 directors, at the time of voting, not at the beginning of the meeting. This is a peculiarity of SatConnect's bylaws. Again, this is in the facts. What happened is that there was no quorum at the time of the meeting because the claimant appointed director left. The board
at the time of voting.
At the time of voting.
Okay.
Excuse me. Therefore, the board lacked a quorum when it consented to the buyout, meaning that the consent to the buyout was invalid according to diversity law. Now, this is one instance in which respondent committed a breach of contract because they invoked a contractual clause and therefore ended the contract in an improper manner. If I may, the second instance in which respondent breached the contract as well is that for the buyout to take place in the first place is that they rely on clause 4 of the joint venture agreement, which can be found on page 18 of the record. According to this clause 4, if there is leaked confidential information, this constitutes a material breach of the JV agreement. The material breach, in turn, allows the invocation of clause 8 and the buyout. Now, everything then hinges on a leak of confidential information, and thus a material breach. However, as it has already been pointed out, on 4 occasions the record makes clear that there is no evidence that a leak of information ever occurred. Therefore, it is our position that clause 4 was wrongly relied on, and clause 8 was wrongly invoked, and that this in itself, the termination of the contract improperly, constitutes a breach of the contract of the JVA. Unless there are any further questions on this part of my argument, I propose to wrap up by dealing with FET. When dealing with expropriation, Claimant has already brought forward the argument that Claimant was denied due process of law. Due process of law, or denial thereof, does not only render the expropriation illegal, but in itself is a violation of the FET standards of fair and equitable treatment imposed by Article 2, Section 2 of the BIT. There are 2 further instances in which FET has been violated. Firstly, respondent abused its public authority to breach the contract. In this instance, it did not act as a commercial entity, but in fact exercised sovereign authority, namely command over the Burstein military.
Just a question, when we look at FET, what kind of standards and elements are we looking at? Because it is such a vague notion.
Absolutely, Mr. Arbitrator. It is our position that claimant does not have to rely on the autonomous standard, autonomous interpretation of FET in this case. In fact, Article 2, Section 2 of the bid suggests that this particular clause reflects nothing but the minimum standard of international law, of treatment of international law. However, even under the minimum standard, we can find decision in support of our case, namely that due process is part of the minimum standard. Namely that the abuse of public authority is also a violation of FET under the minimum standard. And finally, that the frustration of legitimate expectations on the part of an investor equally is a violation of the minimum standard that any investor under international law should be entitled to.
And what is the source of your international law?
Mr. Arbitrator, I would respectfully refer the Tribunal to decisions such as Waste Management, Moot and USA, and Thunderbird, which are all NAFTA decisions. And NAFTA, the relevant article in the NAFTA treaty, has been interpreted as being equivalent to the minimum treatment rather than an autonomous standard. I see that my time is almost elapsed.
And you think that governs our consideration of
It is my
principle?
Excuse me. It is my submission, it's claimant submission, that the cases cited, Waste Management, Mondev, are the relevant principle is similar to these, is relevant for these proceedings. And since that principle in those cases reflects minimum standard, it supports the claimant's case, even if under this, in this bit, the standard is the minimum standard rather than an enhanced standard. Does this answer your question?
I think so.
Unless there are any further questions, this concludes the end of my submissions.
Thank you, Mr. President.
Before you proceed, we have from their name tags the names of counsel, your opposing counsel. We do not have your names.
They were misplaced.
The clock's not running. Would the two of you please give us your names for our records?
My name is Lauren Dydick.
Lauren, how do you spell the last name?
D-Y-B-E-C-K.
And you want
Yvette Fenton.
that Benson?
Fenton. F-E-N-T-O-N. Thank you, Mr. President. Thank you, members of the Tribunal. The respondent is here today in protest. The claimant has characterised what is a normal commercial buyout between two parties as a government conspiracy. I'll respond to the arguments made by the claimant, and in doing so, I will argue in defence. Firstly, that there was a breach of the confidentiality clause in the joint venture agreement, meaning that the buyout was valid and the taking of the shares cannot be an expropriation. Secondly, that the respondent has accorded the claimant fair and equitable treatment because the procedure behind the buyout was valid and the claimant had ample opportunity to respond to the allegations against it. And lastly, that in any event, the respondent is entitled to rely on the essential security provision in the bid. Turning to my first argument, that there was a breach of the confidentiality clause in the joint venture agreement. Members of the Tribunal, the whole issue of expropriation turns on whether there was a breach of this confidentiality clause. Now, it's the respondent's first and foremost position that the acts of Veritech are not attributable to the respondent. However, if the Tribunal is of the opinion that there is attribution, then the respondent argues that the buyout was valid because the claimant did breach the confidentiality clause in the joint venture agreement. The buyout clause requires a material breach to be invoked, and under the confidentiality clause, any breach of confidentiality is a material breach of the entire agreement. Members of the Tribunal, there was a breach of confidentiality for 3 reasons. Firstly, because the burden of proof rests on the claimant. Secondly, because the claimant cannot discharge the burden of proof. And lastly, because an adverse inference should be drawn from the claimant's failure to adduce any evidence. Turning to my first proposition, that the burden of proof rests on the claimant.
In the ICSID case AAPL, the tribunal stated that there exists a general principle of international law placing the burden of proof upon the claimant, and that international responsibility of the state is not to be presumed. The party alleging a violation of international law giving rise to international responsibility has the burden of proving that assertion. Members of the tribunal, in the present proceedings, the claimant is alleging a violation of international law, so the claimant has the burden of proving all the factual elements necessary to support its case. One factual element that is necessary is proving that there was no breach of the confidentiality clause. This brings me to my second proposition, that the claimant cannot discharge the burden of proof. Members of the tribunal, the standard of proof in this arbitration is that the tribunal be reasonably convinced of the truth. It's proof on the balance of probabilities, preponderance of the evidence, more likely than not. The confidentiality clause in the joint venture agreement prohibits the parties from disclosing or allowing to disclose, directly or indirectly, any matters related to the SatConnect project. Unfortunately, members of the tribunal, there is an unfortunate lack of evidence in this case. However, Crawford and Lee state that in cases where proof of facts presents extreme difficulty, the tribunal may be satisfied with less conclusive proof. The evidence that the respondent has brought before this tribunal is enough to reasonably convince you that there was a leak of information. The evidence is a newspaper article from the Berestan Times newspaper, in which a highly ranked defence analyst indicated that there had been leaks of encryption technology, systems and intellectual property of the SatConnect project. The journalist in the article also points out that the claimant has admitted receiving requests from its own government for encryption keys. The tribunal should accept this evidence as true because there is nothing else in the facts to contradict it. Further, members of the tribunal, the respondent state owns no share in the Berestan Times and it is considered to be an independent newspaper. Moreover, the defence analyst in the article has no connection to Veritech. My last proposition, members of the tribunal, is that an adverse inference can be drawn from the claimant's failure to adduce evidence. This tribunal can only determine this dispute based on the evidence presented to it. Members of the tribunal, it was the boards of SatConnect and Veritech who made the decision to execute the buyout clause, not the respondent state. So the information available to the respondent, the evidence available to the respondent is limited. In contrast, the claimant was directly involved in the buyout. It was the conduct of the claimant's personnel that was being complained of. Members of the tribunal, absence of evidence is not evidence of absence. Surely the claimant could produce details of an internal security investigation conducted after these very serious allegations were made. The IBA rules on the taking of evidence allows this tribunal to draw an adverse inference from a failure of a party to adduce evidence. Members of the tribunal, an adverse inference can be drawn from the claimant's failure to produce any evidence whatsoever in support of its position that there was no breach of confidentiality.
How do you prove a negative?
Mr. Arbitrator, the claimant could perhaps provide details of an internal security investigation after these very serious allegations were made. Evidence of ingoing and outgoing communication, evidence of security footage. It was the claimant's personnel whose conduct was being complained of, and it was the claimant who was directly involved in all these allegations. Surely the claimant could produce evidence of some sort to support its allegation. Members of the tribunal.
Sorry, what paragraph of the IBA rules are you referring to?
I just have a 9.5, Mr. Arbitrator. The claimant cannot discharge the burden of proving that there was no breach of confidentiality. and cannot discharge the burden of proving that the buyout clause was breached. Accordingly, members of the Tribunal, the buyout clause was properly invoked. Turning now to my second argument regarding both expropriation and due process behind the buyout. The claimant has argued that the SatConnect board decision in favour of the buyout was invalid because quorum requirements were not met. Members of the Tribunal, the claimant appears to be relying on clarification 156 in its allegation that there was no quorum, which states that Alice, the claimant's director, did not participate in the voting. Now, the Tribunal has already raised this issue with counsel of the claimant. It doesn't matter if Alice participated or not. All that is required for quorum is presence. Under Barristan law, quorum is required at the moment of voting. The clarifications state that Alice did not participate in voting. There is nothing to suggest that she was not present during voting. Accordingly, members of the Tribunal, Alice was present when the vote was taken, satisfying the quorum requirement of 6 directors. Turning now to my third argument. Members of the Tribunal, even if you do find that there was a breach of the buyout clause, there is still no expropriation for 2 reasons. Firstly, because the measures taken were not permanent, and secondly, because there has not been a substantial interference with the claimant's rights. The first reason is that the exercise of the buyout clause is not permanent. Members of the Tribunal, only an interference which is of a permanent nature will substantiate a claim for expropriation. And Wheeler states that an interference cannot be permanent where a measure is by nature temporary, may disappear, or which may require further proceedings before the taking crystallises. For example, members of the Tribunal, in the ad hoc case SD Myers in Canada, the Canadian government imposed an 18-month export ban on toxic waste. Now, despite the ban continuing for 18 months, the Tribunal still found that the ban was temporary because it was temporary from the outset, and the Tribunal declined to characterise the measure as an expropriation. Similarly, in El Guinea in Argentina, the Argentine government's emergency laws enacted during its economic crisis were held by an ICSID tribunal to be temporary, despite lasting for 4 years. And this is because an economic crisis is by nature temporary. It will eventually pass. Members of the Tribunal, in the present case, the effect of the buyout is temporary. Escrow is, by definition, not permanent. So long as the shares are in limbo, so long as the shares are in escrow, they are in limbo. And if this tribunal finds in favour of the claimant, its shares will be returned. Like Wheeler said, further proceedings are required before this taking will crystallise. Therefore, it cannot be a permanent measure. Members of the tribunal, the second reason there can be no expropriation is that there has not been a substantial interference with the claimant's rights. An interference will only amount to an expropriation if it interferes with the investor's control and use of its investment so substantially that it renders the investment absolutely useless. Members of the tribunal, the focus is on how much the investor has been deprived of. There has been no substantial interference in the present case because the claimant's position has not been substantially altered by the buyout. The claimant's degree of control over the investment is unchanged. Prior to the buyout, the claimant was only entitled to 4 out of the 9 board positions on the board of directors and only held a minority shareholding of 40%. It did not have the right to control SatConnect or its operations to begin with, so the claimant has not been deprived of control over SatConnect. Likewise, the claimant has not been deprived of any profits. SatConnect was not generating any profits yet. Deploying the systems was the next step in the project, so prior to the buyout, the claimant would have only been contributing capital and not receiving any dividends. Lastly, members of the Tribunal, the claimant has not been deprived of the right to sell its shares because sale required approval of the Board of Directors. Accordingly, members of the Tribunal, the claimant's rights have not been substantially interfered with, and this, coupled with the fact that interference is not permanent, means even if the buyout clause was invalid, there cannot be an expropriation.
I'd like, if you would, to return to a couple of earlier points that you made briefly. And the first one is the breach of Clause 4, the confidentiality provision. My reading of it suggests that you need to find that there was a breach of the confidential aspect or information. And as I understand it, factually, you relied on these newspaper reports.
Yes.
Do you think that's enough to justify the whole responses of your respondent with respect to the claimant? That's question number one. And secondly, with respect to the quorum, I understand your argument to suggest that claimant's director was there,
Yes.
that you have evidence that she was there.
No, Mr. Arbitrator, I'll answer the quorum question first. The facts are equivocal as to whether she was present or not, making it just
But then
as
you
likely.
concluded that, therefore,
Let me rephrase, Mr. Arbitrator. It's just as likely that she was present as that she wasn't present. The claimant is trying to impugn this meeting, and in order to do so, the claimant must show that she was not present. The
And-
facts, sorry.
I'm sorry, but the word was not participant. You're concluding that that means she was present.
Yes, Mr. Arbitrator.
I mean, you have to conclude that, right, to suggest
Yes,
your
Mr.
argument.
Arbitrator, she was present, but she did not participate.
But you don't have any proof that she was in fact present.
No, Mr.
Only that
Arbitrator.
she did not participate.
No, but the burden is on the claimant. See, the claimant is the party condemning the conduct in this meeting.
I understand you're arguing the shifting the burden.
Yes.
But that goes to my first question.
Your first question as to
What
whether a
does it take?
newspaper article is enough.
Yeah.
I'll reiterate, members of the Tribunal, what Crawford states, that in cases where proof of facts presents extreme difficulty, the Tribunal may be satisfied with less conclusive proof. I'll also reiterate that it was the boards of SatConnect and Veritech that conducted the buyout, not the respondent. The evidence available to the respondent is limited. If I may turn back to the issue of expropriation, members of the Tribunal. There cannot have been an expropriation because the effect of the buyout was not permanent and there was no substantial deprivation of rights to the claimant.
What about the intellectual property rights?
Mr. President, the parties' agreement was that in the event of a buyout, the claimant would receive its paid-in capital. Its paid-in capital is $47 million, which has been placed in an escrow account made available for the claimant. It's the respondent's position that the buyout was executed as per the terms of the parties' agreement, and the $47 million is also as per the terms of the parties' agreement. Members of the Tribunal, in regards to...
Let me follow up. Tribunal Inc. invested $47 million in Satco. Plus, it brought with it intellectual property rights. So you're saying the intellectual property rights, for purposes of the expropriation, are valued at zero?
No, Mr. President. The parties had freedom of contract when they entered into this agreement, and they've agreed that if a buyout is conducted, The only compensation that the claimant receives is its paid in capital. Its paid in capital is 47 million. Now the case would be different if this tribunal found that there was an expropriation. However, it's the respondent's position that the buyout was valid and the amount in escrow is as per the terms of the parties' agreement.
I have difficulty with the argument that that the expropriation was not valid because it was temporary. Because you seem to base the escrow, you seem to base that argument on the escrow. And it seems to me that the escrow is simply an intermittent stop towards handing out the money. And that you say it is the decision of this tribunal that will decide whether or not money is given to the claimant or their shares.
Yes, Mr. Arbitrator.
That doesn't, to make an expropriation argument depend on the outcome of this arbitration seems to me to be circular.
No, Mr. Arbitrator.
Well, it actually makes this tribunal the buyout or the executioner for respondent's government if we find for respondent.
No, Mr. Arbitrator. In regards to permanence, the focus must be on whether the deprivation can disappear or whether it will be temporary. Escrow is by nature temporary. The claimant cannot contend that this is a permanent measure when it has the potential to have its shares returned. Members of the tribunal, I note I'm running out of time, so I'll conclude the respondent's defence. Members of the tribunal, a buyout is not an unusual feature in a joint venture agreement, and buyouts occur regularly in the commercial world. And this is exactly what has occurred here. Veritech conducted a normal, valid commercial buyout as per the terms of the parties' agreement. Members of the tribunal, this is commerce. This is not a government conspiracy. If you have no further questions, that concludes my defence.
Rebuttal of
5 minutes, but I won't be taking up the time. Members of the tribunal, I would like to respond to 2 points that respondent has raised. Before I get to these 2 points, I would just like to mention that respondent in his briefs has also brought forward, has argued the affirmative defense of essential security interest, which has not been raised in these proceedings, which is why I do not plan on addressing them unless the tribunal would like me to address the issue. I would then like to make 2 points. One regarding the burden of proof, the other one regarding compensation. Respondent's case seems to be that by spreading some sort of rumor, this is enough to impose an obligation on a party suffering from that rumor to disprove the rumor. That is quite a strong contention, a surprising contention to make. As for the details of this particular case, it is true that the presence of Ellis Sharpton, the claimant appointed board member, at the time of voting is not unequivocally established. However, given the circumstances of this case, given that she knew what was at stake, the buyout, that she knew that she could deprive the board of a quorum, it is a reasonable inference to draw that she wouldn't have been so daft as to stay and just watch what was going to happen, but leave and prevent that actions detrimental to her from ever occurring. Now, on the point of compensation, everything hinges, whether or not compensation will be paid in the first place, hinges on whether or not the buyout was legal, was legally conducted. If it wasn't, then a claimant is entitled to much more than what was provided in the contract. Secondly, I think there's this should be clarified. What has been paid into the escrow account is a sum of money, not shares. Even if this, what is in the escrow account, is given to claimant, this is not the shares, but just the value which respondent claims is equivalent to the value of the shares. And this we object to. Unless there are any further questions, this concludes my rebuttal.
Questions?
No question.